He treated his wife like the wife he loved, the mother of his children, until the sudden, unexpected event happened. Imagine you are so in love.
We are not getting to a crazy in love argument here, Tipton. It's day 10. I thought this trial was going to go well into next week. So did you. So did the judge. Honestly, I think so did the defense attorneys. Am I right? But yesterday, in a shocking and stunning turn of events, the defense put on no case. Remember, they don't have to. The defense is not obligated in any way to present a case. They do not have to present anything. They can rely solely on the fact that it is the burden of the prosecution to prove their case beyond a reasonable doubt. They don't have to do a thing. But we all kind of expected they were going to because of the defense's opening statement, wherein they talked a lot about what the defendant saw, thought, felt, did. And those are only things that will be in evidence if the defendant testifies. The defense made a lot of promises, and they weren't that long ago. I found some of the statements in the defense's opening to be surprising, shocking. When the defense was talking about Brian Walshe going down and cleaning the kitchen and checking some emails and then going up and getting into bed with Anna and then realizing that something was wrong and then nudging her again and then nudging her harder to the point that she fell on the floor, none of that's in evidence. But it doesn't mean it's not in the jurors' minds and that they're showing up today going, excuse me, what was all of that? And I have to wonder, based on something that the judge said yesterday that I've been thinking about quite a bit, when the court told them at sidebar or side of the bench that the defendant would not be able to get into the fact that he had pled guilty to counts 2 and 3. I wonder if that alone was the change of circumstance, because we heard the defendant, I'll characterize it as bragging, my characterization. We heard the defendant in his police interview saying that he pled guilty with integrity. And that's not what Anna Walsh was telling her friend, according to the testimony in this case. But to his federal case, he pled guilty with integrity. I wonder if he was counting on the benefit of those guilty pleas, even though I am sure his defense attorneys advised him that it is not necessarily the case that the judge will let that in before the jury. I just have to wonder if that's part of the change of circumstance. I'm very interested to see what the defense is going to argue, because I think it's going to be burden, burden, burden. They didn't prove. You don't know. You can't know. Burden, burden, burden. For the prosecution, it's going to be receipts, video, Google searches, DNA, timeline. That's what I think we will see from the prosecution. But I guess we'll see. You know why? Because we are going live to court. It is closing time. Okay.
The evidence of the searches. The dark, troubling.
Depraved, would you say?
Evidence of the searches.
Would we say depraved?
They began at 4:52 a.m. on January 1st of 2023.
I was wondering about that. Thank you.
How do you dispose of a body?
But what time did Mutlu leave? 1:30? Now we're at almost 5 a.m. I'm glad he brought that back.
Look at all of those searches. Think of how they evolved. Consider how they go from one subject to another in rapid fashion. Searches conducted by a man that is in disbelief, in confusion.
Oh, that's objectionable too. Because he's stating facts that are not in evidence. And there is a fine line between stating facts not in evidence and arguing. You can say to the jury, do those seem like searches of somebody who's in their right mind, or do those seem like searches of someone who's panicked? But you can't say the defendant was panicked. That's not in evidence. You can argue that the jury can infer, but this is a couple times that he's been real close to the line.
Rapid fashion. Searches conducted by a man that is in disbelief, in confusion. 5 hours spending with his wife on New Year's Eve, enjoying life, talking about the future. And then the sudden and unexpected tragedy happens, and it doesn't make sense. If Mr. Walsh began to make those searches with murder in his heart as a result of murder, then why isn't the first search how to dispose of a body after murder? Because that's
the third search.
the search that occurred 6 hours later.
Your argument right now is, but ladies and gentlemen, it took him 6 hours to say murder. So not murder shaped.
And when you see that word murder, no one would not react to that word. And certainly as jurors in this matter, you're expected to react in a way to that. What does that mean? Does that mean that he in fact murdered his wife? But think about it in context. In this
that's
case,
argument.
on these facts, context matters.
Yeah, it does.
And so the first time the word murder is used in these horrific searches is 6 hours after they began. And I tried to ask Trooper Garino, one of the forensic specialists, as he called himself, associated with the Mass State Police.
Fair.
I tried to ask him.
Fair.
Well, it's only logical, isn't it? That if you don't get results, you change the wording. We all know that.
We said this
From
yesterday.
our own common experience. And you look at those searches
Algorithms,
that
am I
came
right?
and went during this time, and the results have to do with funeral parlors and cemeteries and things like that.
Well, if someone died spontaneously, wouldn't you need a funeral home or a cemetery? Ladies and gentlemen, algorithms, am I right? He had to narrow down the search results because he didn't want to call a cemetery or a funeral home because they might have some questions.
And there's searches about cleaning, and there's searches about how to clean up. You'll read them. And even though they don't talk about murder, they are equally upsetting because you're thinking, as jurors in this case, he's thinking about cleaning up the basement.
They're thinking about the varnish on the
Thinking about
bedroom
how you
floor.
clean a concrete floor.
Why did they ask about a wood floor then?
Context. 1,034 pages of digital data, 3,667 records taken from his MacBook. Not one record, not one page refers to any plan. Not one record, not one page refers to any intent to kill. Nothing. So keep it in context when you review that exhibit and those searches, and ask yourself, why is a man searching now if he had intended to kill his wife? Why is the man searching now if he had planned to kill?
Wait, no. Yes. I thought you were going to argue this. We talked about this last week. Last week, we talked about whether or not Tipton was going to get to. If he had planned it, he wouldn't need to go to Home Depot on the first. He would have bought all that shit earlier. He was going to try to expand the time of planning. He wouldn't need to do all the searches if it was planned. He would have done it before. Planning can happen in a second. He's going to try to embiggen the time. We talked about that last week.
He treated his wife like the wife he loved, the mother of his children, until the sudden, unexpected event happened Imagine you are so in love.
We are not getting to a crazy in love argument here, Tipton. He is so in love that what? He couldn't bear the thought of his wife having a proper burial of a grave that he and his kids could visit when she suddenly died of natural causes, a place where he could honor her, a place where he could put loving wife and mother. I don't, this is a choice.
You support your wife to get a job in D.C. You're going to take care of the kids because, one, you love your children, but you want to take care of them. You want to share property and protect the assets, so everything goes into her name to protect it because he has this federal case. So let's protect our financials for the future. And then you hear the testimony of Alyssa Kirby. Yes, she was upset. There's no doubt Anna Walsh was upset. What exactly she was upset about? Maybe things weren't going really well in the affair she was having. Or maybe she was, in fact, stressed out. Who wouldn't be? They were living apart. She wasn't seeing her children. Now, maybe, it's up to her. Anna Walsh was a wonderful person and a wonderful mother. And that's why he loved her so much. But she had another life, and she went to Dublin, and that's another piece of evidence. They want to suggest to you he knows something about Dublin. Where is the evidence of that? None. And you hear Alyssa Kirby choked up with tears, sobbing on the stand, but nonetheless recalling a conversation she had on 12/29, 3 days before January 1st. What does Anna tell her? Well, I don't know if I love them as much as I used to. Those are her words. I'm paraphrasing, but that was the gist of it.
I'm surprised you're bringing this up.
But I want him to take responsibility. Why? Not so she could kick him out, not so she could leave him, so they could reunite as a family. That was what Anna Walsh was talking about. That's what she was thinking, even though she was stressed. And I'll just tell you,
Love
when you
and
look
probation.
at that evidence, you'll see that that email exchange
I'd
was
forgotten about that.
deleted. It's right there in the evidence. And then you heard the federal probation officer saying he wouldn't be allowed to go there. He'd have to get permission. So yes, did Mr. Walsh lie to his probation officer for what reason? So he could take his wife out for a New Year's dinner, and that evidence, and the evidence that you saw in that champagne box, is what their life was right at the moment before the tragedy happened. That is the evidence. I'm sorry I talked for so long. I apologize.
I feel strongly.
Mr. Walsh loved Anna Walsh, the mother of his 3 children.
There's a line
no
there,
evidence
sir.
that he deliberately premeditated a murder. There's no evidence that he ever intended to kill Anna Walsh. None whatsoever. Mr. Walsh is not guilty. He's not guilty. Thank you.
Interesting to me that the defense did not say, I'm asking you to find Mr. Walsh not guilty. He just simply stated, Mr. Walsh is not guilty of murder. There are things that we expected in Tipton's argument, and there are things that we did not expect in Tipton's argument. But at the end, he bookended his argument with a soft-spoken intro and a soft-spoken outro to his closing arguments. And at the end of his closing arguments, talked a lot about the fact that the defendant loved his wife. He planned a reservation for dinner the night of the 1st, that's not evidence of premeditation. And he talked about the Google searches, the knife. He talked about the fact that January 1st is the day when Anna Walsh died. He read into his closing argument what Anna Walsh wrote on the champagne bottle box, looking forward to the new year. But he didn't read what Brian Walshe wrote on the champagne bottle box, because it wasn't looking forward into the new year. It was a comment on the present moment. He commented on Jem Mutlow's testimony. He commented on the tech evidence. He commented on his own cross-examination regarding the spicy videos and apologized to the jury for that, which I thought was a good break in pacing to give the jury a moment to relate to him when they might have not been relating to all of his argument the same way. And he focused on that there is no evidence in the house that something violent happened in the home other than the basement. And he really tries to pull the focus down to the basement, talks about the fact that Brian Walshe was searching how to get blood out of concrete, doesn't mention that Brian Walshe was also searching how to get blood out of wood floors, potato, potato. Talked about the fact that there is no evidence of planning, no evidence of premeditation, that it's the government's burden to prove planning and premeditation. And there are times in his closing where I think he stepped really, really into telling the jury what Brian Walshe was thinking, feeling, and doing when there's no evidence of it. He's allowed to argue, couldn't somebody be panicked? Couldn't this be evidence of panic? Don't you see evidence of panic? But he was saying those searches show someone who is panicked. There's a few searches that he left out. He says that the prosecution was cherry picking some of the digital evidence they brought in. The word murder didn't appear in the Google searches until 6 hours after the Google searches started, because he was trying to refine his search results, because he was getting search results of like funeral homes and things. And he needed to refine the search results. We thought he might argue it, and he did. But again, Tipton has some really difficult facts to work with, and he was going to make the most of it. But there are some critical Google searches that the defense left out of their closing arguments, which might stand out for the jury and might not. It's up to the prosecutor to highlight it. There's things he brought up in closing that I had forgotten about. He brought up that there was a text message from the Nightshade restaurant. Interesting choice, but from the Nightshade restaurant saying that there was a reservation, that he actually put down $500 on his credit card to make a reservation at Nightshade restaurant for a New Year's Eve dinner, which I completely didn't remember. So if the prosecution's going to argue that that large swath of time to take his mom home, not to take your mom out tonight, to take his mom home, that he was lying to probation, not to clean up a murder scene, but to take his beloved wife out to dinner. So I really am interested to see. Also, a number of you are saying in the chat, I don't remember if those things came in. The credit card records are in evidence and the cell phone records are in evidence. So even if they didn't read them in, all of those things are in evidence. Even if they didn't read it to the jury, those records are all still in evidence. So if they are in those records, then they're in evidence, even if the jury didn't hear it, even if we didn't hear it. He also highlighted to the jury that they should go back and read the text messages between Anna Walsh and William Fastow, and that some of those text messages would be upsetting or cause someone to be in a rage if they were seen. And then he tried to argue that there's no such thing as iMessenger. So we don't know when the defendant said that stuff was coming across his phone that was for Anna. We don't know if he was talking about iMessages because there's no such thing as iMessenger. And maybe that could be Facebook Messenger, where his cross-examination on that area went. So we saw some of the same arguments, statements he made in opening when he was talking about athletes die suddenly, people in good health die suddenly. It was the almost exact same language as we saw in opening. But after the defense closed without the defendant testifying, is the jury along with the defense going, yeah, I see it that way? Are they nodding along, going, yeah, that's a good point? Or are they sitting there going, that's not exactly how I remember it?
Anna Walsh is dead. because he murdered her and he intended her death. Anna Walsh is not missing. She never walked out of her class at home on January 1st of 2023 between 6 and 7 a.m. to take an Uber to Logan Airport. She wasn't going to D.C. for a work emergency. There was no emergency. She didn't say goodbye to her son. It's just a story that the defendant told people. But since January 1st, Anna Walsh has not been seen by her friends or co-workers or by the people who love her. His internet history, written words, he was looking at best way to dispose of a body. Better to throw away crime scene clothes or wash them. Crime scene. Can you be charged with murder without a body? Anna was dead. The defendant killed her, and he began researching how to get her money, how to inherit, how to get away with the crime. And he might have gotten away with it, but he didn't know that his map book was syncing with his son's iPad, the same Apple ID. His demeanor changed during the interview on January 8th when the police mentioned the searches on the iPad. Not because the iPad involved his children. He had already involved the children in his lives. But because he knew he was caught. We know he had already involved the 6-year-old when he had the 6-year-old say that he saw his mother when she left the house on the morning of January 1st. The son could not have seen Anna leave the house. The defendant had already killed her. Listen to the recorded interviews. During the January 5th interview, the defendant spoke about what his son supposedly had seen. And the defendant involved the 4-year-old by saying that the 4-year-old hid the defendant's iPhone 13 mini. So, the defendant's phone made a reservation at Nightshade Noodle Bar for New Year's Day, after the defendant told Anna that they were going to have a special party. This is ironic because the defendant was very clear with police on January 7th that he and Anna had no plans for New Year's Day, and the defendant also knew that he would be violating the terms of his federal probation by going to a restaurant on New Year's Day. But let's look closely at Exhibit 170 about the Nightshade Noodle reservation, which was on the defendant's iPhone Mini 13, which the defense just said was deleted. And if you look on page 2, on the bottom of one of the bubbles, you will see that the message was deleted on January 1st at 7:59 and 5 seconds a.m. This happens to be one of the times that the iPhone Mini 13 was unlocked when it was supposed to be missing.
Why would you delete the reservation from the restaurant? Right, because your wife's already dead, but you told Jem that the phone was missing.
The forensics show that the defendant's phone was unlocked 4 times, and it was plugged in on January 1st. You heard testimony that the phone had a password of 197512. And then the January 4th recorded.
That's one of those longer passwords that takes like 37 plus years to crack, by the way. It wasn't 1212.
Interview, you hear the oldest child needed help with his iPad password, which was 121212.
That's a good connection.
Didn't unlock the defendant's phone. The defendant blamed his misplaced phone on one of his children when he said that the children hid it. But it makes no sense that a 4-year-old somehow unlocked the defendant's phone and deleted that text minor.
It's a good point.
Listen to the defendant's recorded interview. The deletion is made when the defendant is supposedly making French toast and playing with the kids. The defendant prevented anyone from ever finding Anna's body. There's no autopsy. Dr. Atkinson told you that the medical examiner can't do an autopsy without a body, and all that remains of Anna are a few hairs, some blood, and a few things that belong to her. Part of a necklace she often wore, her hunter boots, a black jacket, a purse, her COVID card, and a few other items in the dumpster in his mother's apartment complex. The defendant searched his MacBook for a murder conviction without a body. Please do not allow the defendant's self-serving act of dismembering and disposing of Anna's body to let him get away with this murder. At the start of this trial, we asked you to use your common sense. When you do that, when you analyze the evidence as you deliberate and continue to use your common sense, you will see that the evidence shows there is only one verdict. Find the defendant is guilty of the premeditated first-degree murder of Anna Walsh. Thank you.
I thought it was a good closing. It was a different vibe entirely from the defense closing. I said during the defense closing, if, the facts are on your side, argue the facts. If the law is on your side, argue the law. And if essentially nothing's on your side, bang the table, bang the podium. The prosecution's closing was not bang the podium. The prosecution's closing was, as I thought it would be, receipts, screenshots, videos, timeline. And I think the prosecution did a very good job of weaving together the facts that are most helpful to them to show premeditation. I am bummed that they didn't talk more about the knife. They didn't. However, I think this prosecution has shown that they have been a bit restrained. It's clear that they trust their jury and that they don't need to answer some of those questions. They did not try to tell you how Anna Walsh was murdered. They told the jury that she was murdered and that the defendant disposed of her in multiple dumpsters to hide the murder. And they brought up the Google searches multiple times. And what did they point to with regard to premeditation? They didn't bring up the large gap of time that the defendant was asking for on January 1st from probation. They left it alone. They did bring up that the reservation was planned, and then that text message was deleted off the defendant's phone during the period of time he told everyone, "Oh, I don't have my phone." And then texted, "Oh, I found my phone." And leaned into the things that are less open for interpretation. I think the defendant saying he didn't have his phone and it was unlocked and locked and plugged in and not plugged in during that period of time with like a 6-digit passcode is less open to interpretation than the chunk of time that he lied to probation asking for, where he may or may not have had a dinner reservation. That's more open to interpretation. The phone, the deletion of the text, less open to interpretation. And the defense said in their closing, our phones and computers know everything we're doing. And the defendants, she did argue, the defendant's searches show you what he was doing and what he was thinking. And I think her bringing in, can you be charged with murder without a body? She said it 3 or 4 times, maybe more. And then wove that into the end of her closing to say, do not let the defendant benefit from his self-serving act of dismembering and disposing of Anna Walsh. Do not let him because he disposed of the body, get away with murder. She highlighted his search with regard to crime scene. Is it better to get rid of or wash crime scene clothes? Didn't touch a ton on the DNA on the knife. The defense did. The defense touched on the DNA on the knife. She didn't. What was he laying the groundwork for that is less open to interpretation? There was a lot more evidence, I think, in this case that the prosecution could have gotten bogged down in, and they didn't. I thought her pacing was good. There were times she definitely highlighted things with her change of tone. And there were times she also got quieter in the courtroom, which is really hard for us, but to much effect with the jury. And I think the prosecution stayed away from things that could be more of a reach. The defense was reaching for the sky, but that's what they need to do. The defense needs to reach every which way. They are looking for a juror that is not convinced beyond a reasonable doubt. They are looking for a juror that's going to fight for them to bring it from first-degree premeditated murder to second degree or to not guilty or to a hang. And the prosecution is saying, you don't have to guess. Look at what he did. Look at what we know he did. And we don't know what he did with the knife. I have some pretty strong thoughts about it, but we don't know. And the prosecution focused on what was known. And that's consistent, I think, with how they've been throughout the case. They have been restrained and focused on what they know. The defense has been focused on where there's room to expand. The Commonwealth really did contract into, these are the things you know, and these are the reasonable inferences and conclusions you can make from what you know, because it is a circumstantial case, and the jury's allowed to make that.
I will give you a quick break as well, but something's been on my mind that I want to discuss now that the closing arguments are over.
Oh?
And that is, I had asked in connection, this relates to the sentencing, at least for the other two counts.
Oh.
I asked the Commonwealth to provide victim impact statements for any immediate family members of Anna Walsh that wish to provide information, and I haven't received that yet. And there might be a good reason for that. I had told you that I was putting off the sentencing until we had a verdict on
The court's asking about the sentencing on the other two counts. Your Honor, the prosecution thought they had the weekend. So we were talking about the two counts that he pled to?
charge of murder. But now that it's a Friday, and I don't want this to linger over until the next week, has the Commonwealth heard back from the Department of Children and Family Services?
Your Honor, we've been in touch with them. They are working on their impact statement. They were hoping to have the impact statement impounded.
Yes.
And I can, as soon as we're done here with the charge, I will speak to the attorney that I've been dealing with. They've been working very hard on this. They're certainly worried about their privacy interests of the children.
Yes.
And the
I think there's a valid privacy
Yes.
interest of the children, and I'm highly likely to
Yes.
impound it, obviously, with the exception of counsel for both sides being able to see it so that they can make appropriate arguments as a result of the victim impact statement.
Yes.
I think the department will be very happy to hear that. And they also, much of what they have is through a social worker privilege, so they're concerned about that as well. But as soon as we break, I will be happy to have that conversation.
Well, I'm happy to hear that there's forward progress because I guess I assumed, because I hadn't heard anything, that you were still not getting the answers to the questions you were asking.
No, quite the opposite. They've been working very hard on this.
All right, I appreciate that.
Thank you.
Anything anyone needs before I step off the bench briefly? Thank you.
All rise.
There are lots of times. Lyndon, I'm with you. Lyndon said, I never thought I'd be saying, yes, please impound that. Same. Normally, I'm like, God, what are we doing? When it comes to the victim impact statements of the children, I think impounding them protects the kids. And for those of you that are newer to Massachusetts, fair. Impounding just means sealing, keeping them private, which means they would be private for the public. The attorneys would see them. The defendant could see them. the court could see them, but they would not be part of the public record where anyone can go to the courthouse and obtain a copy of them. I think that's appropriate. There is so much when it comes to talking about the kids of Brian and Anna Walsh that keeping their impact statements private is one of the least things that can happen. I agree with the court. I don't think anyone would object. I don't think the defense attorneys will object. And then they were asking about victim impact statements from Anna's family, but the children as well. And the court wants to know where they are with getting those impact statements because the court put over sentencing on the other counts until after this is done.
Everybody saw the question?
Yes, Your Honor.
My suggestion is that we, there are 265 exhibits, and I ordinarily have sent in an exhibit list that the parties have reviewed, and I would think that would be an appropriate way to assist them in their evaluation of the evidence, but it needs to be cleaned up. In particular, on a quick review of it, photo 52 should say something other than butcher paper.
Yes. And 189?
Also the same term?
No.
What were you calling it? What kind of paper? Bench?
Bench paper.
That term is used throughout. So what is it that is, that term is used in other numbers? So is it something about that particular photo that is problematic with that description?
Oh, I
mean,
I just don't like it, but
I know you don't like it, but I'm trying to distinguish between, I think there was one witness who used that term butcher paper as opposed to bench paper. And I don't think it was the witness that was associated with that. This is just the old-fashioned terminology that people often use to describe that paper. I think I used it at the side of the bench one time, not in front of the jury, but just with you. But I think that is there's a more neutral characterization that would be appropriate and more in line with what the witnesses actually testified to. But as to the other language in 189, it seems to me that that's what the witness testified to, right?
that's right. Yes, Your Honor.
Anybody, let's all take a moment to look through the list right now and see if there's anything. I'm going to do that right now. The answer to their question is 97, by the way.
Yes.
Let me just take the time to look through these, and you do the same.
You see the rug in Exhibit 97?
Yes.
Is it your opinion that that rug is the rug that you testified to yesterday?
It looks similar, but I can't confirm if it is or not.
And do you recognize the room that that rug is in with the fireplace?
Yes, this looks like the first floor living room.
Okay, and that's the room that you examined, correct?
I did not do a full examination. It was one of those areas that I did a brief visual exam as I was walking through to the second floor and first floor.
All right, if you can take down Exhibit 97.
All right, so I'm going to write back to the jurors, and I will give them the name of, or the number of the photo, which is, I'll answer it as exhibit number 97, and here's an exhibit list to assist you.
Thank you, Your Honor.
As is my custom, at 4 o'clock, I send in a note on every day the jury's deliberating, asking if they want to stay until 4:30. That note will be marked as the next exhibit for identification.
And what did they say?
It gives them the option of staying until 4:30 or suspending and coming back on Monday in this instance, and they've elected to do the latter.
Oh,
So we'll bring them in, send them on their way. Just as sure as council, make sure you're back here a few minutes before 9 o'clock in the morning on Monday. Have a nice weekend.
Thank you.
and the jury will resume deliberating on Monday at 9 a.m. Eastern. So if we go live on Monday, I will let you know. They are not going to deliberate over the weekend. They are done with their deliberations for today. If they do not come back on Monday, I will keep you posted with notes in the app that the jury is taking a lunch break. Remember, no verdict between 1 and 2 p.m. Eastern, and generally done for 4:30 for the day. If they come back on Tuesday, we'll be on Verdict Watch on Tuesday and cover some other topics. I wouldn't be shocked if they come back Monday. I wouldn't be concerned if they don't come back Monday. We are talking about building a puzzle with smaller puzzle pieces. The jury is going to want some time. This was still a 9-day trial. It felt like zoom at the end, but it was still a 9-day trial with a lot of evidence. They are asking the jury to come to a decision on a no body first degree murder case. They are going to need some time to talk. So, am I concerned one way or the other that they're taking the weekend? No, not at all. And I don't think the Commonwealth is either. The instructions in Massachusetts tell the jury like 4 or 5 times to slow down. Slow down. Talk about everything. Do not take a straw poll. Other jurisdictions don't say that. And a lot of juries will go back, pick a 4-person and be like, should we just see where everybody's at? And then go from there. Massachusetts expressly tells them not to do that. And I think it does keep the deliberation time a little bit slower because it tells them to go through everything first versus take a straw poll, see where you're at, and then start talking. It's a different process, but it does not surprise me that they need some time to talk. So I wouldn't try to read the tea leaves on the jury on a Friday of a holiday week. If we get to like Thursday next week, if we get to like the end of next week, we'll have that conversation a little bit more, but I don't think we're going to get to that point without some questions either way. And if there are questions in court, I will either go live, or if it's very quick and the jury wanted to see Exhibit 97, I'll let you know in the app. Okay? All right, everybody breathe. Be cool. Slow down. It's going to be fine. Waiting for a verdict is stressful. It's stressful for the parties. It's stressful for the defendant. It doesn't need to be stressful for you. The jury will decide when they decide. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.